So you're in a lawsuit. This video series is about some of the most frequently asked questions about the lawsuit and litigation process in the United States. In this first video, we're going to talk about the basic steps to initiate a lawsuit. If you need to sue someone, how do you do it? I'm Mark Lyda from Lyda Law Firm. Let's get started. One take, Mark. You know, classic. All right. So I have to say that the first step to initiating a lawsuit is to try to resolve your dispute without having a lawsuit. The reason for this is that lawsuits are pretty much almost always terrible experiences for everyone involved, even if you win. So I really encourage people, if you can resolve your differences outside of court, try to do that without suing someone. Then again, there are just times in life when you have to sue. Sometimes the only way to deal with a bully is to stand up to them. And in those instances when you have to sue, here are the basic steps for doing it. Once you've exhausted efforts to try to resolve the dispute outside of court, you can next escalate that by going to a lawyer and discussing your options. Sometimes it helps to write what's called a demand letter or a cease and desist letter, which is basically just like a nastygram written by a lawyer on their letterhead, and maybe you send it certified mail just to show the other side that you've talked to a lawyer. The lawyer thinks you have a case. The lawyer has a way of saying it that will cite to certain laws and show the legal basis for your side of the story. And it's all just a way of showing the other side that you're taking this seriously and you mean business. I recommend that in those demand letters that you have a deadline for the other side to respond, so you're not just waiting before filing your lawsuit. Also, if you take steps to try to resolve your dispute outside of court, or you do things that would delay suing, like writing a demand letter instead of actually suing somebody, make sure you're keeping in mind your statute of limitations. A statute of limitations is the time limit that you have to sue somebody. So depending on where you are and what type of claim you have, it might be, for example, I can only sue this person 3 years after I find out what they did to me. And so you need to figure out the statute of limitations first, because that tells you the time frame that you're working with here. So after you try to resolve it out of court, after you have your lawyer write a demand letter, neither of which are usually legally required, the next thing you need to do before suing is make sure that any contract you have with the other party allows you to sue. Sometimes contracts say, all right, if we have a dispute, we agree to do mediation, which is like a settlement conference where we just have somebody help us try to resolve our dispute voluntarily. So maybe the contract says we'll agree to have a mediation 30 days before anybody sues. Sometimes the contract might say we agree to go to arbitration, which is like a private court in a conference room outside of the courthouse, instead of suing. So whatever you do, make sure that you read any contract you have with the other side before you actually file suit, because the contract might also say where you have to sue. Any dispute under this contract will be resolved under the laws of the state of Colorado and Denver County District Court or something like that. So read that contract before you sue. The next step to initiating a lawsuit is to write your complaint. So the complaint is the document that opens the lawsuit. It says your side of the story. It says the facts of why you are suing. It says the legal basis for suing, and it says exactly what claims you are bringing against the other side. Breach of contract, negligence, infliction of emotional distress, whatever the claims are. So you write that complaint, or I recommend you have your lawyer write that complaint. Once you have the complaint written, you will file that complaint with the court and you will serve it upon the other party. So this is done using a process server. Sometimes the sheriff in your hometown can do it for you, or there are private companies that will charge maybe $50 or $100 to go personally hand the complaint and the summons to the other person in the lawsuit. The summons is the document that says, here is your complaint. You have to respond to it by X date in this particular court. And it is served like in a packet with the complaint on the other person in the lawsuit. Your process server will send you back an affidavit, which is a sworn statement saying, I served this person at their house at X time on X date. Or it will say, I wasn't able to find this person because they were dodging me. If that's the case, there's a workaround, which is too detailed to go into for this video. But anyway, so after that process server sends you back the affidavit, you are off to the races. The ball is now in the court of the other party of the lawsuit, and you have initiated your lawsuit. So that's the first step in our So You're in a Lawsuit video series, which is how to initiate a lawsuit. In other words, how to sue someone. In other videos in this series, we'll talk about what if you get sued, and we'll talk about all those steps that follow after you actually begin the lawsuit. Thanks for watching, and please remember to click like and to subscribe to help keep legal education accessible for small business owners.